We will now cover the new laws. I'm John Macy from the Municipal Law and Litigation Group, SC, formerly known as Ahrens, Moulter, Macy, Riffle, and Larson. And with me today are Michelle Drea and Mark Paulette from the Education and Certification section of the Department of Revenue. We should note that as part of your first meeting agenda, we always recommend that you go over the new laws. And this year in particular, because of the new laws that we're going to set forth for you today, we're recommending that you show this section of this chapter, this section of the tape, to all of the members as part of your meeting. The new law deals with the legislature passing Act 68 in November of 2017, and it took effect immediately. Also, there was a new Supreme Court case that many of you have heard of, Milewski versus Dorver, which came out in July. Although some of the Act new law deals with procedural changes, which only affect you indirectly, some of the new law is very important for you as board members to understand. We're going to start by asking Mark to explain the changes in the dates when the Board of Review must meet.
The law changed the 30-day time period from the second Monday in May now to a 45-day period starting the fourth Monday in April. So what that means is that first meeting will occur separate from the open book period. That means no longer will the open book and the Board of Review be held on the same day. This allows for a number of things. One is to allow the taxpayer to prepare their case and information. And it no longer allows for the assessor to make changes during that 7-day period. That means the assessor, upon completion of the roll, must stop any changes or make those changes prior to those 7 days.
Michelle, could you explain that a little bit? Because I know there's going to be some confusion out there as to what can occur between that 7-day period.
Certainly. In that 7-day period, if the assessor elects not to sign the affidavit, they may make changes during that time. So in other words, if you have open book and in that 7-day period you do not sign the affidavit, you can certainly go ahead and make those changes. However, if you elect to sign the affidavit at the close of open book, then you would not be able to make changes. I believe the standard practice is to wait and sign the affidavit at BOR, so I don't think this will impact things in that manner. So if you elect to maintain that practice and sign the affidavit at the BOR, you can make changes during that 7 days. But again, it's open book, 7 days, BOR, which is a pretty significant shift from what we've had in the past. No more open book and BOR on the same day. And I believe I'll mirror Mark's sentiments when I say I believe that the root of this change, statutory change, was to allow taxpayer time to collect evidence after the open book if they were going to continue on with appealing their value.
Now, I want to clarify a couple things, and we have you two here as the experts. The department never recommended open book on the same day as Board of Review. This is a long-standing recommendation from the department. Mark, is that correct? That the Board of Review should not have occurred on the day of Board of Review.
Correct. It again allows the taxpayer time to prepare their information, and 7 days is an adequate amount of time to do so.
And I think we need to clarify, Michelle, for the board that in case they get questions, because again, much of what we're talking about procedurally here happens before the board meets. And so this is assessor and your clerks dealing and the taxpayers dealing with this issue for the most part. But we think it's important for you to know that it's part of the new law. And inherent herein, as I understand it, the department feels that all the notices that the assessor is required to send out after open book, before change of assessments, the 15, 30 days, those types of notices, which we've talked about previously, they all should be done prior to that 7-day period.
Ideally, yes, absolutely.
I mean, you would say that that's the department's position, that the statutory notice requirement should be satisfied before that 7 days starts to run.
Yes.
Absolutely. At the first meeting, the assessor can provide to the board the steps the assessor went through in providing notice, whether it be in a maintenance application or in a revaluation application. There's that time period for the municipal representative to go through what steps were taken in notice according to the law. I think we agree that the board at that time will be informed of the notices made by the assessor, the number, the type, etc.
The board's role is to confirm, right, that those things have all occurred.
And I just want to clarify then, we've got the 7 day, all notices are done. The role technically is supposed to be complete. But the department, it's evolving, the department's position in regards to this new law and exactly on how to implement the same. But currently, your feeling is that changes under the waiver procedure could still occur during the 7 day as long as the affidavit hasn't been signed. Once the affidavit is signed, obviously the assessor can make no changes. You've all been taught that, or will be taught that on this tape. But up till then, the old practices of allowing the assessor to meet with new property owners maybe they haven't met with before, or follow-ups from the notice that came from the open book. And when we talk about the open book, we should be very clear. The roll is open for a long period of time. Open book is the minimum 2-hour period that the assessor statutorily is required to have scheduled and made available. Many communities do many, many more hours and appointments available and things like that than the 2 hours. But we're talking about the minimum 2-hour statutory period that we call open book, because there's an open roll and an open book, and that sometimes gets confusing. But during that 7 days, they can still make changes if they follow the waiver procedure.
Yes,
Okay.
and as long as that affidavit is not signed.
The most important change affecting the Board of Review in Act 68 and the new case law deals with the change that allows a property owner that had refused to let an assessor into the house or onto the property to still appeal their assessment. This is a complete reversal of the prior law allowing now the property owner to appeal their assessment if they, even if they deny entry. We're going to explain that change. We're going to talk about what has not changed in the new law, and we're going to give you some direction as how to handle the situation when it arises. First, Michelle, could you explain the department's position on the new law and the right to deny entry, and then even be able to appeal your assessment?
Sure, John. First, I'd like to touch on the Milewski versus Dorver case, which is really where the statutory change sprung from. And in the Milewski versus Dorver case, we had property owners that brought an action against a municipality alleging excessive property tax assessment. They challenged a statute that said, it was 7047A, and they challenged the fact that not allowing an interior view would be a bar to the Board of Review. And the Supreme Court in that case held a few things, two of which are important to you today. One, that the property owners had a due process right to contest the tax assessor's valuation of their property as excessive. So they said they had a due process or a Fifth Amendment right in accessing BOR, which is a quasi-judicial body. And the second piece was that the tax assessor who enters a home is really acting as a government agent, and conducting an interior view in a private property is subject to the Fourth Amendment privilege, so it's protected by the Fourth Amendment. So those are two big holdings, John. We had one that an assessor entering a home that's a protected environment for the Fourth Amendment, and that you shouldn't have to cede your Fourth Amendment right in order to get to a Fifth Amendment right, that due process right to be in front of the Board of Review. And so that was really sort of the essence of that case, which is a shift from what we'd had in the past.
And that's important because your interpretation of the new law is based in large part on that ruling.
Correct.
And
Correct.
we're going to get to that.
Exactly.
But you got to tie the two together, and that's what you're trying to do for us.
So I want to illustrate what sort of rights we're talking about and how that plays out in the statutory changes as we move forward. So again, it's important to remember, Fourth Amendment right in your home, you're protected. You should be able to say no to a government agent if you like, and not have that impact whether or not you can be in front of the Board of Review, which they consider a judicial body, and would attach that Fifth Amendment right. So moving forward, Act 68 then said that the BOR could not deny hearing to a property owner who does not allow an interior view. But in the act, it did allow the BOR to deny a hearing to someone who had denied an exterior view. So again, we're still talking about the same thing with the interior view, but when we get to an exterior view of the home, the new statute in Act 68 said that the BOR could still continue to deny access based on a denial. Now this is the interesting part. Our guidance on that statute is to disregard it. We believe that you should allow access to the BOR regardless of whether or not someone has denied an exterior or interior view. And we do that because of the language in the holding in Milewski versus Dorver is a pretty strong holding. So we're trying to encourage access to BOR and encourage handling these situations sort of in evidentiary ways rather than in an access way. So allow access and then handle the evidence. We think that would prohibit possibly further litigation. So that is our guidance about interior versus exterior view, whether or not a property owner denies view.
Okay, so let's summarize a little bit for the Board of Review. The old law, we all knew and were taught that if you denied an interior view and the assessor followed all of the procedures, they did not have a right to come before the board.
Correct.
Exterior view was never really an issue under the old law because under the trespass laws and under the waivers or exclusions to that and things like that, there was never an issue. But now, and we're going to go to Mark now in a little bit to talk about what the assessor has to do to get access to the property. But bottom line is you're saying that regardless of whether the assessor followed all the steps for interior or exterior, even if the property owner denies an interior inspection or an exterior inspection, the department is recommending that you allow them to appear before the board.
Correct. Absolutely.
So Mark, I don't want to go into a great deal of detail because this is what we would teach at the assessor seminar, all the things the assessor has to do in order to cross their T's and dot her I's. But just give us a little sense of what the assessor is required to do to get on the property or in the property.
Understood. As a Board of Review member, recognize that the assessor will go through a series of events and forms that they've pre-authorized with the department. So the department created a PR 300 form. It's simply a letter that the assessor issues during a revaluation when they are requesting an interior inspection. This is important because this hits the letter of the law for notifying the landowner that they're looking for access to that property. Now, as a Board of Review member, you may not have been aware of the efforts the assessor went through to obtain interior information or exterior information, and it still may be that way. But recognize at your 2-hour meeting, your first meeting, the assessor and the clerk, maybe even your attorney representing your community has gone through those steps, and the assessor is following the law as is prescribed by the department. Simply put, that may just be a form, issuing that form and tracking the denials and the acceptance of the interior reviews. So that's it. As a Board of Review member, you will understand that most of these efforts are borne upon the assessor and their legal representation and how they're meeting the law requirements. It is, simply put, maybe just a mailing and keeping track of those notifications.
So in summary, the assessor on this aspect, on Mark's aspect, the assessor had procedures they had to follow in the past. There are more detailed procedures, and we're asked under the new law to distinguish between the right for an interior inspection and an exterior inspection. But the department is saying, based on the case law and the constitutional rights protected by that case law, regardless of what the new law is saying about if you follow the procedures that Mark has briefly outlined, they're still saying you should give the property owner a right to appeal their assessment to the board, even though they've denied the exterior and all the conditions have been met. Is that a correct summary?
I would agree with that. I would say that I would like to distinguish the cases in which where there's a bar to BOR due to not following filling out forms. So there's a difference between when we're talking about barring access to BOR based on a denial of view, which is a constitutionally protected right. You don't have a constitutionally protected right when we're talking about requirements to fill out forms, which is like the 7047, 7AD, all of those different forms, all the different hoops that you have to follow through with in order to achieve a hearing in front of a BOR. Those are still in effect. So as you don't have a constitutionally protected right in not filling out forms, those are still in effect. The only situation where we are suggesting absolute access is when you're talking about view. When you're talking about internal or external view of a home, that's a Fourth Amendment protected right, and so that's something different. Everything else that you're used to in terms of accessing the BOR remains the same.
Michelle, that's a great segue. You're talking about other things that still would be bars to having the right to appear before the Board of Review, and the new law actually deals with one of those and makes some changes, as I understand it, to the income method of assessment and procedures in that regard. So, Mark, could you just briefly explain that to the board?
Right. No person can appeal to the Board of Review if that value was made by the assessor using the income method. Therefore, no later than 7 days before the first meeting of the BOR, the person must supply the assessor with that income method and expenses as well. So again, this new law does not eliminate these other measures. One is providing income and expense information.
Mark, I thought there was always a bar to appearing before the board if you didn't provide your income information. And I know that the new law deals with this, but what is the change, if you could summarize?
The change is the 7-day requirement prior to the first meeting. Again, it's giving time. Time is of the essence in digesting information provided to the assessor, and that is, in fact, the change.
Okay. Now, we told you that we were going to talk about the change regarding inspections of property, your right to come before the board if you've denied access, interior or exterior of a property. And now we want to talk a little bit about what is not changed. And first and foremost, many of the things that we've taught you all these many years and the things that you're going to hear on this tape have not changed. First and foremost, the taxpayer still has the burden to show that the assessor's value is not correct. Now, you know that the assessor's value is presumed correct. That's a basic tenet as established by the legislature in the Board of Review law. The other main tenet, and another court case that we're not going to go into detail for just because time does not allow, but another court case came out and reiterated these things that have not changed, not because that was the purpose of the case, but just ironically, after the Dorver case and after the new act came out, there was another major case of guidance to assessors more. But in that Wisconsin Supreme Court case, they made it very clear that the taxpayer has the burden, the assessor is presumed correct, and even more importantly, what we've hammered for years, the Markarian hierarchy is still alive and well in the state of Wisconsin. So now we're going to proffer to you the situation where the best information the assessor has available to him or her is not an interior view of the property,
Correct.
and in some instances isn't even an exterior view of the property. So I'm sure many of you out there are going, how do we handle the situation when the assessor hasn't been in the property? And here the board, the taxpayer is here presenting evidence. So we're going to have just a general discussion and suggestions for you on how to do that. And did you want to start, Michelle?
Sure,
please?
be happy to. There's a couple of things I want to talk about. First, if you have a property owner that's contesting their value and they present evidence that the assessor did not have available to them while developing the value, a couple of things that we're going to talk about, a list of questions that you can ask about that evidence, provide you a template so you can evaluate the credibility of the evidence to see how you feel about it. And the second piece of information I would encourage you to remember is that the BOR also has a subpoena power. So if you feel that more evidence or more information is necessary in order to act on or decide what value is accurate, you can always seek more information. That is something that's available to you. So keep that in mind. Did you anything?
Well, Mark, you want to add anything generally before we get into the specific questions? I think as Michelle's asking that the board should, how they're going to deal with this. I think you stated it well before, and maybe you can expound upon it. You said the taxpayers in the past have always come in and said, he didn't take into consideration my basement leaking. He didn't take into consideration, that I've got mold and asbestos. They always say that. We're very familiar with that. But now we have this new dimension. Assessor hasn't even gotten into my house. How can they assess my property? Give us some thoughts on that.
Well, the assessor that has not been in that property will have used traditional methods of assessment, which is properties of like style, age, grade, and condition. The assessor doesn't set the value so much as it is an assessment of all property being alike. That's equity and uniformity. That's what that means. So the details of an interior inspection, while all important, the aggregate values are also equally as important, so that everyone is assessed the same. The details is what the board is in fact hearing each year: the right to assess, the right to improve records, the right to deny entry, as well as we've spoken about, is also in there. The other aspect of this is where the assessor is going off the best information available, and they do that for a number of years until a revaluation is needed. And what the board should recognize is if it's been in that 7th, 8th year, and between revaluations, the assessor may have to update records at this point, and that's what's missing in this appeal. Is you're right, that assessor has not been in that property, and subsequently you do have a taxpayer appear before the board and go with an appeal. I anticipate it'll be business as usual once again, where the appeals won't increase or decrease because of these laws. They will maintain depending upon when a revaluation is done.
So I think our message to you at this point, before we get into detailed questions and process, is that although this is a major change through the court case and the act, that the property owner can deny access, interior, exterior, and still get a hearing before the board, what happens practically for you is probably not going to be any different. It sounds like it's going to be a big difference, but it's not going to be a big difference, because many of the taxpayers who've come in and appealed their assessments in the past, as Mark has articulated, are coming in saying that even if they were in my house, they didn't look close enough, or they haven't been in my house recently enough. The assessor has a lot of information that he or she has on the record cards.
They're confident with that information for the most part. And any changes the board will make this year let's say in our hypothetical example, the board will understand that the assessor will revisit that property in detail the next year. It all starts over again.
And so the assessor has a lot of information, and so they're not assessing in a vacuum. They're going to decide a value based on the best evidence that they have, looking at comps, looking at their record cards, looking at when the last time they were in that property and things like that. So what our message to you is, although it's a major change, it's not procedurally going to look a lot different. The property owner has still got the burden. They're still going to come in, and they're still going to tell us that the assessor's made errors or is wrong in their assessment because she didn't take this into consideration. The only thing that's different is they may be telling you things they couldn't take into consideration because they couldn't get into the house.
Correct.
And that is, I don't want to downplay that that's not significant, but procedurally, it's not a whole lot
I would
different.
say, in fact, I think it's data collection. It's a data collection issue. What the biggest swings that we've had in this act and in the case law is really about collecting data ahead of the valuation and how you collect it, what you do with it. But in terms of procedure for board of review, I really don't think it changes a whole lot. You might have one tricky piece of evidence that we envision. So the scenario would be that the property owner comes in, the assessor's developed the value without seeing an interior view. The property owner asserts a piece of data or evidence saying this particular thing impacts the value. Board of review, you need to take a look at this. And the assessor saying, I didn't see it. I couldn't have taken that under consideration. So that is, I think, the one impactful scenario. I don't think it'll be a lot of them, but I do think that's the one impactful scenario that the Board of Review might see. And so we've developed a list of questions for you to ask in that scenario. Again, you have property owner coming, contesting their value. They are presenting evidence, whatever it is, maybe photos or testimony regarding what's going on in their residence. The assessor didn't have access to that data or evidence. What do Board of Review, what would you say about that? What would you do? And I would say that there's a list of 6 questions that I would encourage you, that we would encourage you to ask regarding that piece of evidence. The first and most significant question, I think, would be what impact does that evidence offered have to the overall valuation? So it can't be something insignificant. This has to be an impactful piece of evidence to the overall valuation. So that's the first question. If the first question, the answer to the first question is there's no impact, well, I think you could probably stop asking questions. It's not relevant then. So that's the first question. Second question, if the evidence viewed by the property owner only, can the evidence offered be documented? In other words, is there something else that the property owner is willing to provide to substantiate or document, corroborate that evidence? So no one but the property owner has seen it. You have the assessor and board of review. They don't have access to this evidence. So what property owner, what other steps are you willing to take or can you take to corroborate your assertion?
Now, I think should we go through all the questions first, or should I?
It doesn't matter.
I think I want to flesh that one out a little bit.
Sure.
Because first, we're really not into the Markarian hierarchy yet, and so these are sort of questions to see whether we're even going to delve there, if I'm understanding you correctly, the impactful. But I can hear board saying to Mr. or Mrs. Taxpayer, well, now will you let the assessor in? We're not recommending that. We're not recommending that they try to twist arms to convince the taxpayer who has refused entry already to now let the assessor in.
Correct. What I am suggesting is it's the property owner's burden to prove what they're asserting. So, and that's not to say that then it's the assessor going in. It's just to simply say to the property owner, well, the assessor is presumed correct. You are, you're asserting this fact, whatever the fact is. How do you plan to prove it?
And another way to say that is, how does that mean that the assessor's created an error?
Correct.
We always say, where's the error from where taxpayer prove what error has occurred? What did the assessor do in violation of the manual?
Mm-hmm. Correct.
Absolutely. So that would be questions 1 and 2. Is it a significant shift? And 2, is it significant? Is what you're talking about significant? And number 2, you have to prove whatever you're asserting. You need to prove it. You have to show that the assessor did something incorrect, that there's something awry here.
And the other point I wanted to make under your first two questions is we're not at this point recommending, I don't think, that the board adjourn and go get an inspection warrant and go through all of that in the middle of a hearing. You're in the hearing. And in past, I know boards who would do things like that, and the department has now come to the conclusion, we don't recommend that. Get your evidence in, have your hearing. Mark's already stated it. You can always come back next year, Mr. or Mrs. Taxpayer, Mr. or Mrs. Assessor, and because every year stands on its own. So listen, your point is, see if it has an impact, and what is the evidence, how can they prove that impact, but not that they go out and gather more data or given more time. Is that correct?
I think so. I think that would be a rare circumstance. You certainly would have the ability to do that, but I don't, under the subpoena power, you could ask for more information, but I would say that that's a rare case.
Yeah, anything you'd like to add on that?
Well, understood. The sales comparison approach, if it's a valid sale, it's something the board would consider, as would the assessor. And many times the board will be faced with perhaps misinformation or information that's not entirely correct. The things the assessor looks for are valid sales, or as we'll move on here, appraisals that were done for assessment purposes, not for revaluing a home. All those things still apply. Age, grade, square foot, descriptions of the property are important in developing a value. And those are usually the things that the board sees, and they will continue to see. This law has no change or impact on what you're using as evidence. We're just trying to help the board understand the use and the application of that evidence.
So I interrupted you on your you went through question 1 and 2, and now let us know what you think the 3, 4, 5, and 6 are.
So number 3 would be to ask if there was a recent sale of the property. Going back to the Markarian, we're going to say, what's number 1? Recent sale of the property. The next question, number 4, would be if there is no recent sale of the property, are there sales of comparable properties to justify the change to the assessor's valuation? So recent sale of the property, no. Are there comparable sales that would justify a change to the presumed correct assessor valuation? The 5th question would be what adjustments were made to the comparables? So we assume you found comparables, what adjustments were made? And the final question is asking regarding an independent appraisal. Was an independent appraisal conducted? If so, what was the result? And is that impactful? What does that mean to the assessor's, again, presumed correct valuation? How does that change it?
So I'm going to take these apart a little bit very quickly. The recent sale of the subject property, that's an obvious one. Mark's already commented on it. That's the head of the Markarian hierarchy. It's the best evidence of value is a recent sale of the subject property adjusted back to the January 1st date. Number 2 is extremely important. Question 4 and 5, I should say, that we're on right now, because the assessor, she knows exactly how to do that. Unfortunately, most property owners do not. And that's the sad part. And they come in with properties they think are comparable, sometimes not even sales, and very seldomly do they make the adjustments. They don't really have the technical wherewithal to do that. And so that's where they fall down on the Markarian hierarchy, is first they got to have sales. They got to have checked those sales to make sure they're arm's length transactions and that they're true sales, as I like to call them, that the department has recognized as sales. And then they have to make all the adjustment to those sales to make them comparable to their property. And so while they're over here talking about a leaky basement or some other issue, which may, even if it's impactful, they still have to follow the Markarian hierarchy. Correct, Mark?
Well, and you are correct. We're looking at the details of that property record card as a board member, as an assessor, and as a property owner. Number of bedrooms, number of bathrooms, number of fixtures, remodels, age, grade, condition. The curable items like a leaky roof, a leaky basement, while they may seem not curable to the homeowner, those are curable items and something that needs to be considered. While the assessor may not be aware of those, the square footage, the correct application of the number of bathrooms, the number of bedrooms are correct. That valuation is probably correct as well. Again, that's for the board to consider and weigh that testimony and that evidence.
And that's talking about the adjustments pretty
That
much. And
adjustment
the
process.
adjustment process, which is tough to do if you don't have the computer program and things like that.
Well, in the background, I mean, that's, you know, at least a week-long class just to start talking about how to figure that out.
Your last question, number 6, is we struggle with, and we have whole sections in the tape and in training on what to do with the appraisals and whether the appraiser is there and things like that. So I think it's important to know that whether they have an appraisal, but keep in mind, based on your prior training and things like that, there are certain department guidelines on, you know, when the department has always said accept it for what it's worth, but if the person who created it isn't there, it's not going to be worth a whole lot. I'm paraphrasing, but summarizing, and you can take it under consideration, but at the same time, you can't give it a lot of weight if the person isn't there to be cross-examined, and their comps can't be checked, and things like that. So have I stated that correctly?
Absolutely, it goes to the credibility of that evidence. It's not very credible if you can't ask questions.
Well, and the assignment, again, was it for assessment purposes? Was it for a refinance of the home? Or was it for the sale of the property? Noting that the assignment that appraisal was paid for is very important to the board, and to recognize that and give it the weight it deserves. Again, if the appraiser is there, that's the best thing you could hope for at a board hearing when an appraisal is provided.
Absolutely.